for levelling up housing and communities and another.
Thank you. Yes, Lord Banner.
May it please the court. I appear with Dr. Burns for the appellant. Mr. Moore's King's Counsel appears with Mr. Grant for the first respondent, Secretary of State, and Mr. Wilcox for the second respondent, Counsel.
Thank you, and that's the full complement.
Sir James is not here.
Expecting, I think, to see Sir James Eady, but he's not.
He's not. He's appearing in another matter.
Yes, I see.
See.
Right. Well, thank you. Just before you get into your stride, a few housekeeping things. We've got to stop at 4:15 today, promptly, because of other commitments. Yes. So we will do that. So just keep that in mind. And the other thing to mention, really connected with that, is timetable. I imagine that you may have, between yourselves, have had a conversation about how the time is to be divided up. This is down for a day and a half. We would like to complete it in a day and a half. So I'm not going to ask now how you've divided the time, but if you haven't already done that, could you please do it at the short adjournment today so that we know, I think when we come back at 2 o'clock.
Yes, we have, we have the experience of the court below, right. Of that having worked. So yes, we have.
All right, well, fine, that's good. I don't think we need to press you to tell us how you're going to do it, but please do stick to the timetable. And the timetable lands us to a conclusion of the hearing at midday, at the middle of the day tomorrow.
Yes, at the latest. At the latest, I will obviously have to have some of the heavy lifting to do, so I expect to be on my feet till between 3 and 3:30.
Oh, I see.
And that will be ample for us to complete by lunchtime tomorrow.
All right, good, excellent. Well, thank you very much, Lord Benner. I think I said 4:15. Yeah, yes, 4:15. We're going to rise. We're going to rise today at 4:15.
Yes, understood.
Yeah.
Understood. My lords, can I check in terms of housekeeping? You should have a core bundle, a supplemental bundle, an authorities bundle.
Yes.
There is hopefully on your desks,
yes,
an additional clip of authorities. There were some parts of the legislation that, on reflection, we felt you should have that were cited to the courts below. Apologies you didn't have. If you would like a refilleted hard copy or electronic bundle.
No, that's fine. And this is an agreed bundle, is it?
Yes, well, certainly there's no objection to it. The habitats regs we put in the PDF format as it was in force at the time, simply because the Westlaw version doesn't have the chapter numbers above the relevant part, and given, you might have apprehended, given the way some of the argument is put, we felt it would help you to have the chapter numbers in there.
No, that's very helpful. Thank you very much for that. I think I will simply keep that separate from the main authorities bundle, which is already quite full. Right.
Well, obviously I'll take the skeletons as read, including, if I may, the interveners skeleton. Which
yes, and I should reassure you all that we are familiar with all the essential materials, if I can call them that, including, of course, the judgment in the court below, the skeleton arguments, the statutory materials, and the salient authorities.
Yes, good, thank you. My lords, can I, by way of orientation, ask you to take up my skeleton, which is at page, relevant part is at page 6 of the core bundle.
Yes.
Paragraph 4, where we seek to crystallise the issue that the court had, the overarching issue the court has to decide, within which obviously are sub-issues, namely whether, when a development within the catchment of a relevant water habitat has planning permission already, any application to discharge pre-commencement planning conditions, no matter what's the subject of those conditions, even if they relate to things like doorknobs, window frames, has to be the subject of appropriate assessment of the entire development's effect on the phosphate loading of the protected habitat, and must be refused if the appropriate assessment can't rule out adverse effect on the integrity of the habitat site in question. And my lords, you'll see over the page at paragraph 5 that the uncontradicted evidence of the HBF, elaborated in the witness statement of Mr. Stevens and Mr. Simons and Bowler's skeleton argument, is that that issue is currently holding up the delivery of 44,000 consented homes, but which is described in the evidence as a conservative estimate, which is approximately 25% of the national housing supply annually. That gives you a sense of the scale of the impact of the issues the court has to decide. My Lords, in terms of structure of my submissions, I'm going to start with some of the background. I will need to delve into some of the nooks and crannies in order to provide context for legal submissions. That may take some time, but please bear with me. Then I'm going to deal with ground 2, pursuant to which we say, irrespective of the question of the proper interpretation of the habitats, regulations and directive, national planning policy, here paragraph 181, as it then was the framework, the numbers have slightly changed. National policy can't make relevant that which is legally irrelevant in relation to sites to which the habitats, regulations and directive don't apply directly. And then the third part of my submissions will deal collectively with what we call grounds 1 and 3, namely that we say the inspector and the judge misinterpreted both the regulations and the directive. And note here, I'll come back to the very end, if on that part of our case you're with us on the regulations but against us on the directive, we lose that part of the case on the facts, but going forward, the position would be different because of the REUL Act as per the intervener submissions. And given the importance of this issue and the urgency of clarity, we endorse Mr. Simon's request for the court to grapple with that issue, appreciating that it's not, strictly speaking, essential for your determination of the case, but there are very strong public interest reasons why it would be helpful.
I mean, that, to be frank and open at this point, that would involve us deciding an issue that does not actually need appeal.
It would, and it would, that we say that... Which
is not something the courts generally favour doing.
But there are exceptions to that, and we say that, well, we endorse what Mr. Simon says about that. At the very least, what we ask the court to do, which with respect Mr. Justice Cranston didn't quite do, is make clear what your position is on the regulations separately from the directive. And then others can do the heavy lifting thereafter as what that means in the REUL Act context. There's a little bit of ambiguity in judgment below as to what the position is on the regulations standalone.
Well, fine. We needn't debate that now, but I've said what I've said.
Yes, I understand. My Lords, because the legal framework to ground 2 is quite different to the legal framework to grounds 1 to 3, I propose, if it's acceptable to you, to deal with the legal framework within those headings rather than as a separate freestanding part of my submission. So that will be easiest to follow.
No, that's fine.
So, turning then to the background, so this is part 1 of the submissions. Can I ask the court firstly to turn up the Natural England Advice Note? That's in the supplemental bundle at page 186. You should see the Natural England 17th of August 2020. And when you have that document, the passage I want to take you to starts at page 188. And you'll see that there's a section about halfway down, development types affected by the neutral issue. 1 additional residential units and commercial development. And the critical paragraph is the first paragraph. Additional residential units within the catchment area of the Somerset levels. Ramsar are likely, there's a missing 2 there, to add phosphate to the designated site. I stress reasons which may be apparent and I'll come on to, via the wastewater treatment effluent, no reference to surface water. Wastewater treatment effluent, thus contributing to the existing unfavourable condition and further preventing the site in achieving its conservation objectives. Therefore, there's a need for appropriate assessment of planning applications that will result in a net increase in population served by a wastewater system. Again, I ask the court just to bear in mind the second reference to wastewater including new homes, and lest there be any doubt as to whether it's wastewaters to surface water in relation to the other kinds of development that follow in the next part of this section. You'll see again multiple references to waste water. You may have picked up the reason I flagged that is a point is floated by the first respondent that one of the conditions which relates to surface water may have had some nexus with this issue. It doesn't for reasons I'll come on to, and this is part of why. Why is it a holding up development? Can I ask the court to go to page 190, and you'll see the mitigation that Natural England suggests is required to deal with this issue, and it's the mitigation that leads to the shorthand nutrient neutrality that you'll be familiar with. Nutrient offsetting mitigation should be in place to avoid other permanent or temporary increases in the phosphate load. So essentially one, by some mechanism or other, reduces the amount of phosphates coming from somewhere else so as to offset the phosphates generated by the proposed development, hence nutrient neutrality. There is some description as to what Natural England has in mind there, and one doesn't need to dwell on the detail of it, but what one does need to now do is go to the core bundle of page 254, 254.
Right.
On this point, 254 should be an extract part of the Home Builders Federation statement that was in evidence before the court below, now reaffirmed by this witness statement by Mr. Stevens before this court. And the evidence, again, not gainsaid, of the HBF below, set out under the heading availability of mitigation solutions in Somerset, was in essence that there are very, very few, and that only a handful of homes are currently capable of securing the mitigation options because of the difficulty in the practical difficulty in identifying and delivering these offsetting solutions. I don't need to dwell on the detail of that, flag that up, that's why it's an issue. 254.
Was there a particular passage you wanted us to look at?
So the passage that runs from availability of mitigation solutions in Somerset through to page 255, for all the reasons given there, it's apparent therefore solutions are very sparse in Somerset and unlikely to leave many of the homes delayed. And then, my lords will see over the page at 256, effect on the delays on house builders because of the absence of solutions in all but very exceptional situations. Second paragraph under that heading, many SMEs have been crippled as a result of nutrient neutrality. They often bought the site significant cost. Contracts we entered into, and they can't get the homes to be delivered to offset that cost. And in practice, while some of the PLCs are able to stomach that, take the hit, local small builders and SMEs can't. And my lords will see the final paragraph, that's where the 44,000 homes figure is derived from, the final passage of that statement. For your references, this is elaborate, I don't think we need to dwell on it, but for your note, Mr. Stevens' witness statement before this court, call bundle pages 35 and 36, paragraphs 8D to F and 11 provide a little bit more colour on that. I don't think it's essential for my argument, so I won't take time on it. But paragraphs 8D to F and paragraph 11.
Sorry, B to F or
D to F.
D to F, yeah.
D
That's
to
what I
F.
thought you said.
That's where he says it's a conservative estimate and provides a little bit more detail. So, my lords, against that background, what I'd now like to do is show you the conditions in this case and some of the background framework for the issue. So you'll find the relevant reserve matter, because we're talking about conditions here on a reserve matters approval. because of course the outline permission phases 1 and 2 have actually been built, and this relates to conditions on the reserve matters approval for phase 3, and that's at page 171 of its supplemental bundle. Apologies, there's some inevitable jumping around of the 2 lines. 171. Hopefully that will be a document with Somerset West and Taunton, which was the second respondent's identity at the time. They've since unified, I think. And for your note, the date of this document is at the end of it, but it's 24th of June 2020. The conditions in this issue, I'd just like to show you, and they start on page 179. So the first of them is condition 3. For development commences a scheme for the protection of trees to be retained should be submitted to and approved in writing by the LPA. And then there is some prescription as to what that scheme should include. 4 is the surface water one, and I'm going to deal with that specifically later, but I'll just show you it. No development should commence until details of the surface water drainage scheme based on sustainable drainage principles been submitted to and approved in writing. There was a site-wide surface water condition to the outline permission for a site-wide strategy, and this had to fit within it, and that's of some significance, as I'll show you. I highlight the 3rd bullet with reference to works required off-site to ensure adequate discharge of surface water without causing flooding or pollution. So there's reference to off-site works to avoid surface water causing flooding pollution. But of course, that's not what Natural England had in mind by way of the neutrality options. They're looking at wastewater offsetting. So I'll come back to that particular condition later. 5, there's another one. No development shall commence until a construction environmental management plan has been submitted and approved in writing. Dealing with construction vehicles, fairly standard form of condition. It's quite prescriptive, and this is of some relevance because, as you'll understand, certainly on the ground too, a key part of my submission is the jurisdiction, in public law terms, of the decision maker when considering an application to discharge a condition is defined by the condition itself. So this sets out what the public law jurisdiction is and frames what the scope of the relevant considerations, because conditions aren't something which is subject to the general requirement to have regard to material considerations of the development plan under the Planning Act, and I'll show you that in a moment. So this is, these are the parameters set for consideration under the application for discharge. And that's relevant to, can policy make legally relevant that which is legally irrelevant point. So that's condition 5. The next one is 6. State roads, footways, footpaths, tactile paving, etc. Street furniture. In reference to surface water outfall, no one takes a point on condition 6 in that respect. Design, layout, etc. of the materials of the roads. Fairly standard condition again, the parameters which are clear from the language used in condition 6. 7 is actually slightly different. Again, nothing really turns it as a preoccupation rather than pre-commencement condition. Again, the considerations left for consideration.
Assume the double negative is a typo.
Where's that? Yeah,
The dwellings hereby permitted.
yes, it must be, my lord. Yes, it must be. Yes. Yes, it doesn't make any sense otherwise. I think that the standard principles of construction of planning conditions would. There's a Southwark case, Southwark isn't in the Supreme Court, which allows for that kind of construction of a condition. And you see again the considerations that have to be considered: their network of cycleway and footpath connections, etc. And then, lastly, 10. samples of the materials to be used in the construction of the external surfaces of the development. So these are the kinds of details which, approval of which is now said to be contingent upon a acceptable appropriate assessment of the entire development. And again, you see the reason to get a sense of the lack of nexus. The reason is nothing to do with phosphates, just sure satisfactory appearance. So those are the conditions. I will take you to the outline of permission a little bit later, where it makes more logical flow to do so. But what I say here, just to echo what I said a moment ago, the conventional and trite position in planning law, I mainly elaborate a little underground too, is the scope of a local authority's powers in relation to an application to discharge a pre-commencement or pre-occupation condition is defined by the parameters set by that condition. They can't, planning law, domestic planning law, refuse to discharge a condition on grounds that are outside the parameters set by that condition. And we say it's obvious at first sight that under conditions 3, 5, 6, 7 and 10, so all of those except 4, which does require a bit more consideration because it says water, and all the others, the variables left over for consideration by the granted reserve matters, left over for consideration by those conditions attached to the granted reserve matters, have nothing to do with phosphates at all. We'll come back to condition 4. And it next will assist, if I can ask the court to go to the decision letter at page 76 of the supplemental bundle.
Are we leaving the?
Yes, we are, my lord. We may need to come back to it on the surface water point.
So 76.
76 is should be paragraphs 9 through 14 of the decision letter of the inspector in this case.
Yeah.
Excuse me. And I draw to the court's attention what's said at the beginning of paragraph 10. The council do not object to the planning merits of the details that have been submitted to the conditions which you can see he lists immediately above. Withholding their agreement instead arises out of the habitats regs. Now, what does he mean by they don't object to the planning merits? Well, you can see that because it's a direct reflection of what the appellant said to him at page 310 of the same bundle. So 310, which you should find there, the appellant's speaking note for the inquiry.
Do you want to look at that?
Yes, if you wouldn't mind, my lord. 310 is behind tab 10.
Yeah.
And at paragraph 6, we should see a sentence beginning, the council has no planning objection. The council has no planning objection to the discharge of the conditions in the sense of the applications to discharge providing the information that the conditions require to be provided and that information being satisfactory. So DL10 was clearly channeling what was said there, which wasn't contested. The council accepted the details have been provided satisfactorily. So to foreshadow what I shall say from the ground too, we say that it can't sensibly be suggested that absent the potential effect of the habitats regime and paragraph 191 of the framework, absent that, the effect of the proposed development on the phosphate loads of the Ramsar would be a legally relevant consideration, be capable in law of being relevant consideration under these conditions. And or that it would be legally permissible to refuse to discharge those conditions as a result of that potential effect. The question is, does either paragraph 181 on it and or the habitat regime, the regulations of the directive, convert that position to one where it was legally possible and indeed mandatory? And that's ultimately the question for the court.
Right.
My lord, now I want to turn to a little bit more detail on condition 4 regarding surface water. So the position we say is the same. Actually, that was how the inspector, as I'll show you, and the judge below considered it too, but it does contain the word water in, so, and my learned friend Mr. Moore's places some reliance on that in his skeleton, so I need to just drill down a little on that. As I said, the inspector and the judgment below didn't distinguish between condition 4 and the other conditions, and no respondent's notice is filed, suggesting that the judge below erred in this respect. I just to give you an indication of how my learned friend Mr. Moore's relies upon it. Can I ask you to turn to his skeleton? It's claim bundle core bundle, sorry, page 43. And within page 43 of the core bundle, sub-paragraph 5 on paragraph 3. And there, Mr. Moore's and Mr. Grant say, round 2, we say that national policy has made relevant what is legally relevant, and that's indeed our round 2. And then they say that the shadow HRA before the inspector indicated that surface water runoff could have a nutrient effect, and condition 4 deals with surface water. So a point is taken, say not actually a point taken by the...
Pardon, I haven't found the paragraph.
Oh, I'm so sorry. It's page 43 of the core bundle, and you see this sub-paragraph 5, it's in parentheses, which is a continuation of paragraph 3 from the previous page. The appellant's ground 2 suggests.
Right, but he seems to be referencing the shadow.
Yes, I'm going to take you to, that's not the document you've seen yet. I'll take you to that, and because the local authority produced their own, what's called a shadow HI, in other words, information to assist the inspector on making his appropriate assessment. And what Mr. Moore says is that document indicated that surface water could have a phosphate consequence for the integrity of the site, and that was clearly a legally relevant consideration in discharging condition 4, which relates to surface water. So, though the inspector, as I'll show you, and Sir Ross Cranston didn't suggest there was anything different between condition 4 and the others, they took a generic approach. All the conditions had the same legal analysis. And although there's no respondent's notice on that point, nonetheless a point put to you is that actually condition 4 is different. And I will take you to the shadow HRA, and if I can get to that in a moment. So I do need, therefore, to spend a moment or two explaining why that's a bad point. We get into pleading points, it's just a bad point. And can I start in relation to this point by going to the supplemental bundle, page 329, 329. That page, you should hopefully have a document titled Appellant's Response to the Council's Additional Submissions. There was a bit of a ping-pong post-inquiry of written reps on various points. And do you see there's a section on LSIC? Now, my lord, can I draw your attention then to what we say here in this context? So, paragraph 3A, we say the matters that are said by Natural England Council be causes of phosphate impact are legally relevant considerations, and then there are these various points made. 1, Natural England's advice, which has to be given great weight, was that foul water, i.e. wastewater, to mean the same thing, discharge was the sole pathway, and that's not an issue which is in play by any of the conditions. So that was our first point. These aren't planning merits points because the point is the inspector didn't grapple with these. He didn't deal with these points at all because he just treated all the conditions as indistinguishable. So that was our first point we made. Second point we say, as Mr. Moles identifies, there are references in the council's document to surface water discharge as a secondary contributor to potential impact. However, he made various points about that. One, they were not evidence. Two, they were illogical, because the amount of phosphates in surface water that comes from rain is not affected. Phosphates are generated from human excrement. That's really the key contributor from the waste into wastewater. Thirdly, we said there was no suggestion in the council's shadow HRA that surface water as a standalone factor would generate either individual or cumulative impacts with other development on the Ramsar. Fourthly, fundamentally, both the shadow HRA and the council's case, and I add and the inspectors and other things, reported to be consistent with and applying Natural England's document, which was wastewater only, as you've seen. And then we took, there's a further point at Roman numeral 3, which was that further and in any event, the parameters in relation to surface water that the council's document suggested may affect the Ramsar, the level of surface water runoff, how much can flow into the ground ultimately, or through the basins, what are called SUDs, the attenuation basins. That was regulated by condition 4 of the outline permission, which requires a development-wide surface water strategy, and I'll show you that had to be approved before reserve matters. And that had its own parameters, and then the reserve matters surface water had to be consistent with that. So the actual considerations of how much surface water went into the ground were fixed by the condition 4 outline permission scheme. So we put those various points before the inspector. The inspector didn't deal with them, and the only way, well, there are only two conclusions to that, either of South Bucks Reason's challenge, which we did make for the court below but didn't need to be determined, or on the basis inspector effectively accepted our arguments de bene esse, but said, well, nonetheless, all the conditions apply the same way. So that even if this didn't, surface water wasn't a contributor, just as the street furniture condition was subject to the nutrient neutrality rules, so too was this. It didn't matter.
Well, yes. We need to read the decision letter for what it says.
Yeah.
And if he didn't deal with these points, he didn't
He didn't deal with them. And I do feel a need, so that you're not sort of taken down a rabbit hole of surface water and distracted from the main issue. I just want to spend a little bit of time on this now, just to really hopefully kill this point so we can focus on the real issues.
So to be clear, I'm being slow, I expect. The point you're killing at the moment is what exactly?
Is the suggestion that my learned friend Skeleton, paragraph 3, subparagraph 5, that the surface water aspect of condition 4 means that even if I persuade you in relation to the other conditions, even if I win on the law, I lose on the facts by virtue of condition 4 relating to surface water.
Yeah, right.
And that's not a point that the inspector agreed, not a point Sir Ross Cranston, he's retired, hasn't he? Sir Ross Cranston made no respondents notice, but the court may not want to take a pleading point in the case that you may want to get to the substance of the matter. And if you did, I want to show you why the substance of the matter in any event is with me on this point.
Yeah.
I don't want to spend disproportionate time, but I feel it's important to clear this up so you're not distracted.
Thank you.
Can I then take you to the local authorities shadow HRA? And that's at page 237 of the supplemental bundle. Sorry, that's wrong. Forgive me. That's a bad evidence. It's page 193. This is where I did warn you, we just have to delve into the nooks and crannies a little bit, and then we'll get back to the big picture. So 193, you should have a picture of some water in the field. And then within this document, if you can go a little bit further on to 201, what I want to draw to your attention here is the first of various parts of this document where it purports to be consistent with the Natural England note. So can I just ask you to note at the top refer to the Natural England Advice Note for further information. It's footnoted at 8. And that's not the end of the story, because if one then goes to 214, in the same document, so this is still the Council's shadow HRA, you'll see a section entitled Background on Phosphorus and Planning Applications in Somerset West and Taunton Council. And you'll see that the starting point is Natural England Advice Note, which is indeed appended to. And in fact, that's why you have it twice in the bundle, because the second version of the bundle is the appendix to this shadow HRA.
Right.
So that's a 218. So read fairly as a whole, the shadow HRA is plainly intended to be consistent with Natural England, as opposed to taking a different approach. And one might expect if it was taking an approach, they'd have said so, particularly where they have not just incorporated by reference, they have incorporated it full stop into the document. Two more features of this document. At 208, you see 6.1.1 assessment of potentially adverse effects without mitigation measures. That's the similar exercise done later in the document. And under impact pathway and description of adverse effects, you'll see wastewater and surface water dealt with in the same breath. There's a lot more text up with just wastewater, but they're dealt with in the same breath on an aggregated basis. There's no consideration in this document as to whether surface water is a standalone factor, and of course it was a standalone factor under condition 4. Surface water as a standalone factor could lead to developments, either individually or cumulatively, having an adverse effect on the integrity of the Ramsar. That's just not a point made in this document. See also, a little further along at 209, when they look at potential assessment effects with mitigation, you have the same structure in the table that follows. Lastly, and then we can mercifully leave this very detailed document, at 248, there's some number crunching. This gives you a sort of sense check of this point. There's a computer model that modelled in this document the phosphate generation of the development. And you have phosphorus loading from additional population, which is the wastewater, value 32.96. And then phosphate loading from land use change 1.37. So just in terms of proportion, we don't need to get into technicalities of this, but in terms of the proportionality, that rather reinforces the point we made that this document not only doesn't contend, but doesn't support the proposition that surface water is a standalone factor, which it was under that condition, had an impact for the integrity of the Ramsar. And so our points on that, as I'll show you in a moment, weren't grappled with by the inspector, so he must have presumed we basically were right, but we were wrong on the law, as opposed to right on the law, wrong on the facts. Lastly, you will recall that the third point we made in the submissions on this was that condition 4 of the reserve matters fell within the site-wide drainage strategy. I just want to show you that, if I may. That requires us to look at the outline permission. I said I'd come to the outline permission. You have that in page 90 of the supplemental bundle, 90. And you'll know you're on the right document because you'll see a date, 22nd of December 2015. Excuse me. Now, there, I think by serendipity, it's also condition 4. I don't think there's any magic in that, so that's page 93. This requires a little bit of analysis. prior to any reserve matters approval, details of a site-wide surface water drainage strategy shall be submitted to and agreed in writing by the local authority. It shall ensure that surface water runoff the site is limited to no more than 2 litres per second per hectare of impermeable area. So it's looking at the amount of surface water runoff. It shall set out the principles of attenuation required for each plot, phase or parcel of land. So it's not open at the reserve matter stage to reopen those principles. These are site-wide principles, and the development should be implemented in accordance with the details of the approved strategy. And then there's various things that techniques that have to be used, and they're listed. So that's really the straitjacket really within which the reserve matters condition operated, and the discharge of that condition you'll find at page 100. So it's actually the next document, dated the 5th of December 2016. And you see there a letter saying, I confirm that details provided for condition 04 are acceptable and are approved. What were those details? Well, the pack of details provided starts on the next page, 101. Nothing turns, I think, on the actual application form, but that's there just so you can see that this is the pack. And can I please show you at 107. Even with my eyesight, it's not particularly easy to read. If anything turns on this, we can try and provide an electronic copy that you can zoom, or it may even be zoomable on the electronic bundle you have. But just to show you, the yellow at the bottom of the page is phase 3, for what it's worth. The yellow sort of square.
The pale yellow is phase 3.
Phase 3 at the bottom, the southwest of the site. So this was approved and fixed by the discharge of outline condition 4. Which shows the surface water strategy and layout and all the things that reference. The small text on the right shows the amount of runoff in the various parts, what are called catchment A, B and C, and basins A, B, C and D. The basins, which are in blue, and certainly those members of the court who've done planning cases will appreciate that developments of this nature have what are called ponds, which were attenuation ponds. So when there is a surface, when there's rain, a lot of rain, the development is designed so as to channel the rainwater into these ponds, and then they attenuate.
They're sometimes called balancing ponds. Aren't
Yes, yeah, exactly. And so that's what those basins are. The various runoffs there, and then just to show you the level of detail which this condition went into, a couple of pages on. Page 109, you have some modelling, and you mercifully for you don't have to get into what the numbers say, but if you just do a page turn at 110 on, you see there's the surface water runoff for each basin. So 110 through to 117 is the details of runoff for basin A, different scenarios, climate change, 1 in 100 years, etc. 118 is basin B. And so on. If you just flick through the page, you'll see there's very detailed. So that's the level of constraint imposed by the discharge of condition 4 to the outline permission, within which the reserve matters condition had to operate in a conventional planning law context. And lastly, just to give you a flavour of how it was seen by the authority at the time, page 104. Excuse me. At page 104, you have the lead local flood authority consultee comments on the application to discharge the outline condition 4, what I've just shown you. And how they saw it is that the first paragraph, this is the site-wise drainage strategy, that's all acceptable. The detailed drainage designs for each phase need to be reviewed to include details to show how any previously constructed surface water drainage systems will be protected and maintained to the design standards. So in other words, what the details have to show is how you're going to achieve and maintain what's been fixed by the condition 4 of the outline. Not revisiting principles, the amount of surface water layout, runoff, etc., etc. Which is why, even if, which wasn't the case, even if the proper analysis of the evidence base that before the inspector was surface water could have a phosphate consequence, the consequence in this case was a consequence of what had already been approved by the time reserve matters condition 4 came to be considered. The horse had bolted. So for really that plethora of reasons, we said condition 4 was of the same category, of the same kind on analysis as the street furniture condition, etc., in the consequence of the issues now before the court. How did the inspector deal with it? Supplemental bundle.
Just pausing.
Sorry.
I'm sorry to interrupt you, but you say the horse had bolted. What I suppose you could put it the other way around. What then was left to be determined?
How the site-wide strategy would be delivered on this phase, the details, the flesh on the bones, not the going back to reconsider the principles that have been fixed, the amount of runoff that had to be achieved from each area. It's how do you deliver what I've just shown you and maintain it. That was the thing, because one of the things the County Council of Appeals, not just how do you deliver it, but how do you ensure that that's then resilient for the lifetime of the development.
But you said the residual question was how the site-wide strategy was to be delivered, and that was all that
Over
was
phase
all
three.
that was left to be
Yes,
decided. Right, sorry, I interrupted you just to clarify that, but you were submitting.
There may be some nuanced variables left over the site-wide strategy, but you can see from what I've shown you, the site-wide strategy both was required to set principles and parameters which had to be then followed. That's what the condition said on the outline permission, and then indeed did so, which is what the material provided and approved did, as I've shown you. But then if I can ask you to go to the decision, page 77. Sorry, forgive me. No, it is page 77.
Yes.
Sorry, 77 of the supplemental.
Yeah.
How did the inspector approach this? 16. The effect of nutrients is not an issue in this appeal, in line with the advice of the Natural England note. So he is purporting to take the Natural England approach, not any further approach. See the first sentence of 16, and the rest, you see the continued reference to Natural England. 17, the correctness of Natural England advice is not a matter of specific disagreement. The question, as he saw it, was whether the advice applies. Now, he said it did. The critical point for the court now being that this was a decision that purported to apply that advice as opposed to do something other than or beyond the advice. As we've seen, that advice was directed exclusively at wastewater, otherwise known as foul water, not to surface. Then 33 through to 36 deals with the site-wide condition relating to foul water, condition 7. That's not a typo, there's not a mistaken reference to condition 4 because there's reference to it being foul water. What he doesn't do anywhere is grapple with any of the points I've just taken the court through, i.e. am I right in terms of characterising the relationship between condition 4 of the outline and condition 4 of the reserve matters? Was I right just to take the point that the Shadow HRA purported to be consistent with Natural England, didn't actually say that surface water standalone had a consequence and so on, so if the proportionality, but all those points I've taken you through, which are made squarely in that document I took to court to earlier, post-inquiry submissions, he didn't deal with. So therefore, as I said, where does that take us? It must be inferred that the inspector saw that the legal analysis and the duty on him, as he saw it, regarding the conditions imposed by the habitats regime was indistinguishable.
Sorry, indistinguishable.
Indistinguishable. So it applied the habitats objection, if I can paraphrase it thus, applied as much to the street furniture condition, to the damp proof with the materials condition, as it did to condition 4. There was no difference of analysis as between those conditions. And therefore, he didn't need to decide whether there was some freestanding reason why, even if that was wrong, even I was right on the law, there was some bespoke feature of condition 4 that meant I would lose on the facts. He didn't go there. And you can see this further at condition 26, sorry, DL 26. Where he says that in terms. Considering the second sentence, the overarching nature of paragraph 181, this applies the habitats objection. I'm going to come to the detail of that analysis later, but applies regardless of the specific subject matter of the conditions themselves. As such, the focus on the NE note on wastewater doesn't affect my conclusion for the same reason the shadow HRA and its consideration of site-specific sources of potential phosphate doesn't alter my conclusions. In other words, I don't need to go down the rabbit hole of is there some bespoke feature of condition 4 that makes it different because of the indiscriminate point that paragraph 181 of the framework combined with habitats means that any condition, whatever their nature, is caught by the habitats objection. And the judge below similarly. So therefore, where does that take the court? Well, it takes the court in this way, that if you're with me on either ground 2 or which is the policy point, if you like, or grounds 1 and 3, which is the legal interpretation point, it's not for the court, particularly in the absence of respondent's notice, but even if there had been one, it's not for the court to second guess whether there might be some differentiating feature condition 4. That might be a matter for, if there was going to be a point that was taken, albeit it's a bad one for the reasons I've shown you, that would be a matter for a new inspector to consider upon a consideration of evidence and fact. The point for the court to decide, with great respect, is the same as between all the conditions. And critically, therefore, I say that the ultimate question for the court to decide is, did the habitats regulations and directive, combined with paragraph 181 of the framework, impose an additional hurdle to the discharge of these conditions, an additional hurdle to discharge these conditions beyond the requirements of the conditions themselves. Additional hurdle of discharge condition beyond the requirements of the conditions themselves. That's really the crux in my submission of this case as decided below, both by the inspector and by Sir Ross Cranston. So I'm going to keep getting it wrong. And that ends, well, unless you have any questions at this stage, that ends part 1 of my submissions of background, and I'm going to turn to part 2, the ground 2 policy point. I'll just wait for my lord to finish the notes and I'll get another drink.
Yeah. So you expressed the crux, the crux of the case in those terms.
Yes.
Did the habitats regulations and the habitats directive, in combination with paragraph 181, impose an additional hurdle to discharge the conditions beyond the conditions themselves?
But beyond the requirements of the condition.
Beyond the requirements.
Yes.
Yeah.
Because the council accepted and the inspector noted the requirements of the conditions were satisfied. CDL 10. So I turn to, and if I may, to ground 2, the second part of my submissions, where you recall ground 2 is, even if we're completely wrong on the interpretation of the Habitats Regulations and Directive. The Habitats and Regulations Directive, of course, didn't apply to the Ramsar. And we say national planning policy, here, paragraph 181 of the framework as it then was, it's been renumbered since, nothing turns on that. 181 of the framework as then was, cannot make legally relevant that which is legally irrelevant in relation to sites which the directives and regs didn't apply to. For your reference, I'm not going to take you to the detail of it just now, but that's our skeleton, paragraphs 25 to 34. 25 to 34. And well, my entry point for this is to go into the authorities, tab 2. Which page 4 to start off with, and that should I hope be section 70 of the Town and Country Planning Act 1990. And section 70 subsection 2 says in dealing with an application for planning permission or permission in principle, the authority shall have regard to the provisions of the development plan so far as are material. Then over the page, amongst other things, any other material considerations. The court will be aware there's a whole body of case law on what any other material considerations does and doesn't mean in that context, which is as a whole under the Planning Acts. And it's that requirement, again, this is fairly trite stuff, that generates the obligation in the Planning and Compulsory Purchase Act, section 38(6), which is at tab, just to complete the picture, tab 4, page 14. If regard is to be had to the development plan for the purpose of any determination made on the Planning Acts, as is the case where section 70 subsection 2 is engaged, the determination was made in accordance with the plan unless material considerations indicate otherwise. Now, an application to discharge a planning pre-commencement or pre-occupation condition is not a decision to which section 70 subsection 2 applies, and thus not a decision to which section 38(6) applies. So the statutory concept of material planning considerations generally does not apply. It's fundamental to this ground. That section 72 does not apply. And this is where I do need then to go to our skeleton, paragraph 25. On page 14 of Core Bundle. 14 of Core Bundle. So it's 26, forgive me. The jurisdiction, this is a point I made earlier, but I want to re-impress in this context. The jurisdiction of a local planning authority relating to the discharge or pre-commencement condition and the range of legally relevant considerations in the context of an application to discharge such a condition is defined by the condition itself.
Sorry, where are you now?
This is Core Bundle, page 14, our skeleton, page 10, paragraph 26.
Ah, paragraph 26.
So, because section 72 doesn't apply, there's no statutory concept of material considerations in play. The parameters of the public law decision are framed by the condition. I mean, I analogize here, but it may help this analogy may help that a pre-commencement condition in essence sort of delegates to a future decision maker specified matters for them to consider. You have the reserved matter and say, we're not going to decide the street furniture now, we're going to leave that for somebody else to consider. And if that isn't, if the court feels that is a helpful, so I'm not saying it is a delegation as such, but it's a sort of a delegate has to operate within the four corners of the delegation granted upon them. so too does the decision maker on an application discharge a condition have to operate within the four corners of the jurisdiction conferred upon them by the condition. We say that's so obvious as to be a sort of sky is blue point. If you need an illustration of that, one illustration is in Authorities tab 10. And Authorities tab 10 is a case called Medina.
Yeah.
So my Lord of Justice is well familiar with this case.
Yeah.
It concerned whether an objection relating to highways matters was something that the local authority could legitimately advance within the context of a condition which is quoted at page 115 of the bundle, page 80 of the law report. You see this, it's not the passage which has 10 in front, it's the next quote, approval of the details. So that was the then fairly standard reserve matters condition, and for present purpose you don't need to get into the details of what the debate was, but what I want to show is how the court resolved the debate. And you see that at the end of at the very last page, 86. Passage, I look back at the wording of the condition itself. So whether the authority was or wasn't able to take the points that it had taken, objections were turned upon the wording of the condition and what things that condition left over, as opposed to statutory general material planning considerations. So, and that's just an illustration of what we say is an obvious and tried to point in any case. So where does that leave us? It leaves us here, my lords, that but for paragraph 181 framework, which it said brought into play the habitats regime, but for that, the effect of phosphate generation from the development on the Ramsar site was outside parameters left over consideration, relevant conditions, outside the scope of the decision. Everyone uses the term jurisdiction or range of relevant consideration, it doesn't really matter, it's just out with the decision. It was a legally irrelevant consideration, not in terms of the viewing 3, that not because it would be irrational, but simply it was prohibited by law because it was outside the scope of the matters left for consideration.
It was prohibited by law.
Yes, it was not capable of being a relevant consideration because it was, say for example, to take the tree condition, for example, the discharge of condition 3 in relation to trees, is using that as a proxy, and we know we can use one as a proxy for the rest because both decision makers below, Sir Ross and the Spectre, consider they're all the same. So taking condition 3 as a proxy, that left over details of how the trees would be protected, how their roots would be protected, etc. The effect of foul water on the Ramsar was, say, but for 181 and the habitats regime, to come on to, so, but for simply not capable of being a legally relevant consideration. This was about protecting tree roots, not about protecting rivers. Nothing to do with foul water. So Walsworth, hence that's, I say, it's a legally irrelevant consideration. That's obviously the cornerstone of ground 2. And the next step is we say that policy, government, national policy, cannot make legally relevant, and indeed here, and not out, determinative actually, consideration, that which is in law irrelevant. That is effectively giving government the ability to legislate. And that was the basis of the decision in Elsick, and indeed Wright's helpful too. I'm going to take you to those judgments in a moment. And so actually, there's a very simple answer to this case. It doesn't even need you to actually determine the difficult issues of construction of EU law and Brexit legislation, etc. Even if they're completely right on all of that, this point gets us home. And so what I now will do is take you to, so the question really becomes, did paragraph 181, was it able to make legally relevant that which was legally irrelevant, bearing in mind that the Habitats law did not apply to Ramsar. And at this point I'm going to take you to Elsick, then I'm going to take you through how the inspectors have dealt with the point, deal with my learned friend submissions, and then come to Wright. And because once you understand my learned friend submissions and my response to them, then you'll see how Wright is of use. So Elsick is at tab 21 of the authorities. The facts are, for present purposes, adequately summarised in the head note. It may be a case that's familiar to some members of the court. So picking up at just above E, it's important for later context to appreciate that the Scottish planning regime had an obligation to have regard to any strategic development plan. That's relevant because it's effectively comparable to Section 70, subsection 2. The halfway down E, in 2011, the relevant planning authority saw a need for improved transport infrastructure. It proposed supplemental guidance saying that the funding shortfall should be met by developers by reference to a tariff per unit, as opposed to by reference to the actual consequences of the development for transport. Then I have the developer, Elsick, wanted to build a substantial development in the area, claimed that the tariff calculation would effectively be disproportionate to the actual effect of the development. Then you see a little later between G and H, the planning authority then converted the supplementary guidance into statutory policy, which triggered the equivalent to Section 70, subsection 2. And the issue for the court essentially was, did that policy mean that they could charge the tariff even though the amount sought was not fairly and directly related to the consequence of the development, so wouldn't ordinarily meet the tests for a planning obligation? The Supreme Court said no, the policy did not make what would otherwise have been a legally irrelevant planning obligation legally relevant. That was the crux of the decision. The passage that I rely upon in particular starts at paragraph 47, and that's a 1428 of the law report, 365 of the authorities bundle, and you'll see in italics question 3, the role of the planning obligation in the grant or refusal of planning permission. The question is posed at 47, what is that role? There's then reference to Tesco case in the House of Lords. Paragraph 48, for planning obligation to be a material consideration, aka relevant consideration, it had to have some connection with the development that was not de minimis. And then there's some discussion of that. And then 51, the inclusion of a policy in the development plan that the planning authority will seek such a planning obligation, i.e. one that offended the legal principle of materiality, would not make relevant what would otherwise be irrelevant. There's then reference to the equivalence of of section 72, which says there's required development plans so far as material to the application. So well, if this is not material, then the development plan can't make it, policy can't make it material. And then E to F, planning obligation, which is otherwise irrelevant to the planning obligation if it's sought as a policy and development plan. Policy seeking to oppose such an obligation is an irrelevant consideration when the planning authority considers the application for planning permission. Now, if that's the case in the section 70 context, where the council, a decision maker's consideration, scope of consideration is broader than in relation to a discharge of condition, whereas then axiomatically ought to apply in the context of a condition where the focus is narrower. So we say, on a straightforward application of LC, and indeed constitutional principle, the government policy can't change the law. Ground 2 should be allowed irrespective of the debate about the regs.
Are there any situations, would you accept, are there any situations in which national planning policy can ever be a material consideration?
Well, it can be yes, a national planning policy is axiomatic. I mean, it's a paradigm material consideration in the context of section 70, subsection whatever it is, 2C, other material considerations.
But that's the kind of case LSIG is about. You showed us the legislation. This is a material, this is where there is a statutory requirement, is this right? To have regard to material considerations.
So there was a statutory requirement to have regard to the development plans so far as is material to the application. There's a tail piece at the end of section 70, subsection 2. You have regard to the development plan so far as is material. It's the same in the Scottish legislation as here. What LSIG said is if it's not material, if a planning obligation is not of a quality that's material in planning law, the development plan can't give it that quality.
Right, I understand that, and that's very helpful. So assume for the moment that we're in the LSIG kind of context, where the statutory framework is actually different from the present statutory framework. But leave that to one side for the moment, if you would.
Yes.
But just assist me, if you would, in an LSIG kind of case.
Yes.
When do you accept national planning policy can be a material consideration?
When it is, when it introduces a consideration that is not legally prohibited. So there's the fewings categories. I'm afraid off the top of my head, I can't remember which one's 1, 2, and 3.
Yeah,
But we'll know there's things that are legally have to be taken into account, things that legally can't, and things that may or may not be subject to planning judgment.
Yes.
Now, national planning policy plainly can influence that the may or may not be category. I think it's 3, but I can't remember for sure. But you know. So national policy can absolutely have an impact, and often has a decisive impact in planning cases on that may or may not be category. What national policy can't do, whether it's in a development plan scenario or in the narrower condition, is affect the other fewings categories, which said you have to take into account X, you can't take into account Y. Policy can't change that because that's legislating by policy. And my submission, we aren't in the you can or can't category of viewings. We are in the you can't. Does that answer my Lord's question?
Yes, that's very helpful.
Thank you. Let me just check where I've got to in my notes. But also at this stage, it would help if I take you to the decision, and going through the decision will come to how the case against me is put by Mr. Justice Cranston and my other friends. To give you the headline, the inspector and I keep calling him Mr. Justice Cranston, sorry, Sir Ross Cranston and my learned friends. The key point they make is this. It's what I call the consequentialist point. They say the consequence of allowing a pre-commencement condition is that development can happen. And if the development happens, there may be a potential harm to the habitat site. That would undermine national policy objectives. Therefore, it's relevant. That's essentially, as I'll show you, essentially the point taken by the inspector, perhaps a little bit less pithily as he wasn't a lawyer than by the judge below and my learned friends, but that's essentially the consequentialist point. And in my submission, that's not the right way of looking at it. I'll elaborate it, but essentially if one takes that approach that for pre-commencement condition, you have to look at how the consequences of allowing the development will affect national policy objectives, as opposed to whether the things that the condition has left over consideration have been satisfied. You A, offend the principle that the conditions have to be determined in the way that I've described earlier, offend the LSIC principle. But where do you stop? Every single development, it may, even leaving aside habitats, a decision on, say, a tree protection condition, for example, allowing any development to proceed, you'd have to, considering a pre-commencement condition in relation to tree protection, you'd have to look at, well, what are the consequences of allowing this development to proceed for climate change policy, for AONB, for Greenbelt, etc. There's no coherent basis of ring fencing 181. So it's very, very dangerous. I mean, slippery slope arguments aren't always persuasive, but here it's a very, very dangerous slippery slope effect of the analysis, of this consequentialist analysis, in terms of how do you actually get developments off the ground. It really undermines how the whole approach to considering a pre-commencement condition. It's just actually as important, probably wasn't appreciated by below, but this point is just as important for the planning regime as the habitats point, actually. So I hope I haven't stolen my own thunder in terms of where the submission is going. But if we can, my lords, go to the decision supplemental bundle, page 76 is the entry point.
Sorry, the reference again,
Yeah, 76.
in the
In the
supplementary.
supplemental, yes. It's the decision letter.
Yeah,
And it's 13 and 13 and 14. So the real crux of it is over the page, but just to give you the lead in, 13 and 14, the inspector does is mischaracterise the question in my submission. He considers the question, does paragraph 181 apply? You see that in second sentence 13, whether 181 applies. If it does apply, then there's the various EU points. And you see over the page, the next heading, does paragraph 181 apply? The real question was not whether it applies, but what its effect was, if any. Could it, as a policy, make legally relevant that which otherwise not? And then 18 and 19, again, respectfully asked the wrong question. He looks at whether the Natural England advice note applied at discharge of conditions stage. But of course, the question was it within the vires? This is really an ultra vires point. Was it within the vires of the decision maker in discharging a pre-commencement condition to refuse on phosphate-related grounds? Then over. Sorry.
That statement raises a question in my mind, and apologise if I'm asking an irrelevant question. But was one of your grounds of challenge in the court below a Varies challenge?
Yes, in essence, that's our ground too. I mean, this was outside the scope of the considerations the inspector was able to consider. Outside his jurisdiction is how we put it.
Could you show me how it was framed?
Yes.
Certainly, I hadn't detected that from.
We didn't use the word virus, but it is in analytically it's the same. It's exactly the same. That's outside the range of the consideration. So it's the statement of facts and grounds is core bundle page 138. And you'll see the point as path I've just taken to it, paragraph 55. Policy cannot make legally relevant that which is irrelevant and then the passages that follow essentially repeat the various points I've made so far, concluding at 71, policy cannot make legally relevant that which is legally irrelevant. I make, by vires, I say that as a short, it's another way of saying the same thing. The inspector was operating outside the framework set for him by the conditions. In all argument, we use the word jurisdiction. There are different ways of saying the same thing in essentially in public law terms. The condition set his task, and he did something that was outside his task. That's what I mean. That's what I meant a moment ago by vires. That's what I mean by it being legally irrelevant.
Are you really saying that the Secretary of State has acted ultra vires in saying what he says in paragraph 181?
Oh, I see. Sorry, forgive me.
Because all the inspector, the inspector isn't making this up. The inspector's just applying
Yes.
paragraph 181, which is why I think he poses himself the question: does paragraph 181 apply?
I don't need to go that, because possibly paragraph 181 would apply in relation to new planning applications. And we haven't actually looked at paragraph. Would it help to look at paragraph 181? It's right at the back of the authorities bundle, because it clearly isn't ultra vires in some cases. The question is really what its effect is, as opposed to whether it was lawful. These are the very, very back of the authorities bundle. I had difficulty finding it, but I think it's like literally the last page. Page 926.
Yes.
So it says the following should be given the same protection.
I beg your pardon, can you give
I'm
me
so
the
sorry,
reference again?
Yes, it's authorities bundle, tab 334, page 926. Sorry, I had meant to take you to this earlier, I forgot. And I'd suggest that the answer to my Lord Justice Singh's question is no, not only do I not need to, but I'm not saying it because look at the way it's phrased. It doesn't say you should, in considering a tree protection condition, have regard to wastewater consequences for phosphate. It says the following should be given the same protection as habitat sites. It's how the inspector gave effect to that in this context, which was ultra unlawful, all those things I've said. Not the actual promulgation of that policy, because it clearly does apply until there's some solution. It doesn't
see missing some subtle point here, but if you were saying that the council had acted outside its powers, that I could understand to be a vires challenge. But you're not saying that, at the moment, as I understand it. You're criticising the reason, the inspector's reasoning, and that seems to be a different category of challenge.
I don't want to get too hung up on I don't need to use the word vires. If that's not a term the court finds helpful, I'm very happy to withdraw that comment. Otherwise, we end up going down a rabbit hole. Certainly, the way some people look at the concept of ultra vires is taking into account a consideration which you can't, or equally acting out, doing something other than the task you've been set. So the conditions say to the decision maker, you've got to consider these things. You've got to do this.
Well, it's a species of Wednesbury error.
Yeah, I mean
Put in one way, it's taking into account an immaterial consideration.
Yes. If it doesn't help, if the reference to vires is unhelpful, I'm very happy to withdraw it. No, not necessary to make my case. The critical point is he's stepping outside of the brief that the conditions set him, and whether you call that an irrelevant consideration, it doesn't matter. The point is, it's clearly, if I'm right that that's what he's doing and policy can't convert that, then that's a public law error.
Lord Banner, forgive me. You began your submissions on round 2 by very carefully showing us how this legislative context is different from section 70, subsection 2, and section 38, subsection 6.
Yes.
Because I thought you were going to make the submission that this is not a legal context in which one needs to be worried about the phrase material considerations.
Well, that's part of, because it goes to the reason why this point may be relevant is because of the consequentialist argument.
I
So the consequentialist is the consequence of allowing a pre-commencement condition is development goes ahead. Therefore, you have to look at the consequence of development going ahead, and that clearly is, in my submission, extending beyond the parameters of what the condition sets into a general material consideration point, as opposed to looking at the brief set by the condition. This the jurisdiction, whatever one calls it, both by the condition it's saying. You have to look generally at the consequence. So that's why I took the court to that. In my submission, it shows the fallacy of the consequentialist approach.
If I understood your submission correctly, you're not going so far as to say that the decision maker is not required by public law to have regard to material considerations. Even though that is not an express requirement here, but what you are submitting is that when you ask yourself the question,
What are they?
what are those material considerations? They are confined by the four corners of the terms of the conditions.
Exactly, my lord. That is exactly my case I'm going to, or the building block of the case. Exactly.
Yeah. And if that analysis is correct, and it may not be, but you submit, if it is correct, then the effect of para 181 of a national planning policy document cannot be to convert what is legally irrelevant into something that becomes relevant.
Yes, exactly. Exactly.
But what I find a little bit puzzling about this is that if it's correct that what is material is confined by the four corners of the conditions, then that would still be true even if an Act of Parliament said otherwise.
Well, no, because the Act of Parliament can change the law. An Act of Parliament could say, when considering the discharge of a planning condition imposed under the Planning Acts, regard shall be had to ... and that would be an overlay, effectively on over and above. But Parliament can do that because Parliament can change the law. The government can't change the law.
Doesn't that suggest that it's a question of rationality?
No, it's not a rationality, my lord. No, because it's a question of, say, jurisdiction or legally relevant considerations combined with a separation of powers. Ultimately,
Well, I understand separation of powers, obviously, and I understand why you put it in terms of jurisdiction, which is, I think, to my way of thinking, a little more helpful than looking at it in terms of powers. But what is the legal basis for the limit on jurisdiction? You say it's not a rationality question. Okay, fine. But what is the legal source of the limitation on jurisdiction?
ultimately, it's. I was going to show you this a little bit later on, but Section 70 and Section 72 of the Town and Country Planning Act say planning permission can be granted subject to conditions. So it's granted subject to the conditions, not subject to anything else. And so then one therefore thinks, well, what's then left over for decision? It's the content of the conditions, not something else.
These can include pre-commencement conditions, so that development carried out in breach of a pre-commencement condition, and there's law on this, of course.
So I didn't hear that.
There is law on the question of
Yes.
development being commenced in breach of a pre-commencement condition.
There is like the Whitley principle and that
Whitley principle. And that is not lawful development.
Correct.
So whatever the condition says, whatever it says,
Yes.
if development is begun in breach of that pre-commencement condition, which requires certain details to be submitted and approved before commencement, then that development is not lawful.
Yes. Or
It wouldn't matter what the condition was.
correct, but there are certain exceptions to the Whitley principle, such as if, for example, you submit a application for discharge of the condition before the permission expires. If then that application.
Yes.
So the exceptions to the Whitley principle are all based upon the content of the condition.
Yeah, but we're not in that territory
No,
here. We're
no.
dealing with pre-commencement
Yeah,
conditions.
we haven't commenced. So,
And to go ahead without getting the approvals you need under the pre-commencement conditions would be unlawful.
unlawful, yes, which is why we haven't. Yes.
And
But-
that, and just to perhaps to help put a context in this, that wouldn't matter. It wouldn't matter what the condition said.
So it could be a breach of any of these conditions.
Yes, provided there were no development shall commit. It wouldn't. So some of them are don't build above the damp proof level and
Yeah.
don't occupy. But for the true no pre-commencement, yes, the principle would apply. And that's my learned friend. So what my learned friend says is that means, therefore, that you have to look at the consequence of discharging the conditions, and if the consequence is to undermine national policy here 181, then that's a relevant consideration. I say that the consequentialist post may be relevant to the subject matter. So obviously, what's the consequence of allowing it for trees is relevant in the tree condition. But one doesn't look at, when discharging a pre-commencement condition, to the general consequences of the development, and therefore of allowing the development, because it's the consequence of the development, the consequence of allowing the development to proceed are the same. One doesn't look at the general consequences of the development, otherwise you go round in circles. I mean, think about how that would work in practical terms.
I wasn't advancing that proposition.
No, but I think my learned friends are on
Well,
analysis.
I'm not sure whether it's right or wrong.
Can I show you? Sorry.
No, go on. Yes, you go on.
It may help if I just continue the structure of the submission. Then, if there
Well,
are any
just before you do go on, I
questions.
want to make sure that
Yes.
my Lord's question has been answered.
Well, if I could rephrase it one last time and then I'll leave it alone. I understand your submission is you say policy can't make legally relevant that which is legally irrelevant, otherwise legally irrelevant. Fine. But then that just takes you to the next question, which is how do you decide what is legally relevant in the first place?
By construing the condition. See the Medina case, that's exactly what this court did. In that case, were the highways objections within or?
But that is assuming that nothing else is legally relevant, which is the point you're trying to prove.
Well, the only way something could be legally relevant beyond the parameters left by the condition was if an Act of Parliament made it relevant. Or potentially secondary legislation that had been enabled by an Act of Parliament. Other than that, other than legislation making something beyond the terms of the condition, the content of the condition relevant, nothing else is. And that's really why I did take, to go back to what my Lord Justice Singh mentioned, that's why I took you to section 70, subsection 2, because it's not general plan considerations. The conditions are of a different quality to the things to which section 70, subsection 2 relate.
But that isn't really what the House of Lords was saying in Elsie.
Well, no, in the sense that
Because there they were dealing with an equivalent, Scottish equivalent to section 70, subsection 2 context, first of all. That's one point.
Yeah.
And secondly, what they were, well, can I invite your submission on this? Could it be said that what's special about ELSIC is that it was requiring the citizen to pay some money? And the law is very careful about when the executive is entitled to require the extraction of money by compulsion, because as I read it, and correct me if I'm wrong, what the court was really saying there was that the per unit tariff didn't have any relationship to this particular development. They were trying to fund general infrastructure. Effectively, it was trying to introduce
tax, effectively, in all but name.
Exactly, it's an infrastructure levy being imposed by condition rather than by statute. Is that a possible way of reading that?
That was the facts of the case, but the principle was about materiality of planning obligations as opposed to, and that was why it was immaterial on the facts of the case. Yes. But the principle was, now, this is the reason why this case isn't quite on all fours with ELSIC. So if paragraph 181 was in fact the Somerset development plan, then we would be on all fours, because that would be then the develop, and it would still, my ground 2 would still be good. It would be slightly different analytically, because then it would be a so far as material to the application section 72. But that would be the comparator. What I say is actually, if anything, I'm in an even stronger position than in ELSIC, because the policy in question isn't the statutory development plan. Even if it had been, that would be ELSIC. It's the narrower national policy in the context of a discharge of condition. So, if anything, this is a stronger case rather than a weaker case than LSIC for that reason. May I just flesh out a bit more how the consequentialist argument was put both by the inspector and the judge and my learned friends, and then explain in light of that how the other Supreme Court case of Wright may be of some assistance to the court in considering this point. So, paragraph 22 of the decision, which we were a little while ago, that's page 78 of the supplemental bundle.
Sorry, which paragraph?
22. And it's 22 is where the consequentialist approach starts, which is then picked up and polished by the judge and my learned friends. LSIC, it says, provides some authority for the proposition that policy can't make legally relevant that which is irrelevant. Turns its own facts. Well, yes and no. The Supreme Court does only decide points of general public importance, of course, so that's not entirely quite right. And he says it uncontroversial, all parties involved in the planning system should expect it will create legal certainty. At 23, he says from that there should be some connection with what's under consideration to paragraph 181. What was the connection he found? Well, that's then at 24 to 26, and that's the consequentialist approach. So he says to pick up about halfway down, the application is not limited to a trigger point. Discharge the conditions would be an authorising act that would allow the realisation of the potential effects on the Ramsar site that the Natural England Note and indeed paragraph 181 of the framework seeks to deal with. As a consequence, Natural England Note is relevant and legitimate to apply the framework policy in respect to the subject matter. So that is, it's polished and perhaps somewhat more articulately put by the lawyers, but that's no criticism of the inspector, that's to be expected. But that's the beginnings of what I describe as the consequentialist point, which is how, apart from the surface water point, which is wrong, as I said, but apart from that, that is how my learned friends seek to defend this part of the case. Now, can I then show you how Sir Ross, I'll get it right this time, Sir Ross dealt with it? That's at Core Bundle 128, page 128. Paragraph 67 of the judgment below. How did he seek to distinguish LSIC? Essentially, a more polished version of what I've just shown you. This isn't the situation in LSIC. The impacts cannot be said to be irrelevant considerations in this development. Who have picked up my skeletons? It's not really a question in this development. It's are they relevant or irrelevant to the discharge of the conditions? The issue is the read across of habitats regs to Ramsar sites as provided by the framework in circumstances where if the project if the project is permitted, there's a typo there which all of us should have picked up on, sorry. If the project is permitted, it will cause harm to the Ramsar site. As Mr. Wilcox submitted, and indeed as he does again here, it's necessary to consider the legal consequences to understand the discharge conditions. Again, it's the consequential. You're allowing the development to commence, and therefore you have to look at the consequence of allowing the development to consent to the national policy here, paragraph 181. As opposed to the approach, which I won't repeat, but I've canvassed upon the courts, which is how one looks at planning conditions. And perhaps just to see how it's put by my learned friends before this court, just to complete the picture, Core Bundle, page 79. This is Mr. Wilcox appears to place a little bit more emphasis on this point than Mr. Moore. They make essentially the same point. Mr. Wilcox's skeleton, paragraph 71, where, having said what the judge has said in that passage is correct, so put it another way, impact is legally relevant to the discharge of conditions because the discharge of conditions would authorise the harmful development. And if that's true here, how do you then say, where do you draw the line? So that's right as a matter of approach in domestic law, because we're not into the EU law stuff yet. Then same would be true in the context of what's the consequence of allowing a development to proceed for climate change policy, for green, for the objective green.
This question, I understand why you say on this approach we don't get into the regulations and the directive. Do you say it's irrelevant that by paragraph 181 the government is endeavouring to comply with our obligations in international law?
Yes, because international law is not directly applicable. It can't be, it's a consideration, but it's not, doesn't have direct force.
But of course, we live in a dualist system. I understand
Exactly.
it doesn't have legal force, but does it mean it's irrelevant?
Yes.
Okay.
It does. In circumstances where you've got a otherwise legally prohibited factor, it's the same. It's essentially, if we are a monist system, then it may well, the position may be different. But in a dualist system, if you've got a, again, going back to the Furious categorisation, it's a consideration which is legally prohibited in law, signing up to an international treaty cannot make what is legally irrelevant relevant. It may, in the fewings you can or you can't category, which I say I think is 3, but I may have got that wrong, international law may well have an impact. But we're not in that territory on my analysis. We're in the you can't as opposed to you can or you can't. So that's the approach that Mr. Wilcox seeks to defend the judgment, and then Mr. Moore's and Sir James in the skeleton, page 63 of the same bundle, core bundle, paragraph 70. The latter 70 starts on the previous page, but the relevant passage is on page 63. And it's the penultimate, the penultimate, pre-penultimate sentences. So the discharge of conditions decision would allow the development to proceed. The potential negative impact arises from the act of discharging conditions, agreeing the implementing decision, regardless of the content of those conditions. Now, that may or may not be right in the EU law context, legacy EU law context, where the analysis is different. But in terms of the domestic law approach to the range of relevant considerations and irrelevant considerations to discharge of conditions, again, that consequentialist approach is heretical.
What's your best authority for saying that in domestic law that is heretical?
Best one before the court's Medina. I mean, to be honest, it's. I don't mean to be glib, but it's such an obvious point that it's sort of a sky, say, prove the sky is blue point. But yeah, Medina is the best illustration for this court. There are others which are of a slightly different quality, which is why we haven't bothered. We were below, but we didn't want to be disproportionate, mindful of need for proportionality and paperwork for this court, where in the context of reserve matters, which is not this, can at the reserve matters stage, you unpick decisions about that go to the principle of development. Answer, no, you can't, which are a reflection of that principle too. So if the court would like more, we can give you more, but we've sought to be proportionate. I don't actually understand the point to be this part of our case in terms of the domestic law, the premise, but for 181 and habitats fair. I don't understand it to be controversial, but say if you'd like more, we can.
Well, the
provide
point may not be controversial, but its relevance may.
Yes,
I think that's where
indeed.
the battleground
That may well be.
lies, isn't it?
But Medina is there
not to doubt the principle. Sorry, I was simply saying I'm not sure that it's a question of doubting the principle in Medina. It's simply saying that this is not a case that engages with that principle.
Yes, as I say, if there's more that we can just provide to assist, there's depending on how the case is put.
Well, obviously you must judge what you need to bring before this court to make good the argument you advance.
Yes. So, well, that's what I'd say. Again, I'm really wrapping up on ground two, that the approach of the respondents, the judge below and the inspector would do violence to what we say is the proper approach to the decision maker's jurisdiction, range of considerations of discharge, pre-commencement conditions. It would mean that national planning policy issued by the Secretary of State could extend the decision maker's legal jurisdiction, legal range of relevant considerations in discharge of conditions cases, so that they have to look at the consequences of allowing the development to proceed for national policy. And there's no legally coherent basis for ring fencing the approach around 181. So, oh wait, it's not a doomsday scenario because it only applies in the habitats context. There's no coherent basis for that, because whilst there are legal obligations in relation to habitats, the legislature has chosen not to extend them to Ramsar sites. So it can't be said, therefore, that the fact that there is legislation which doesn't apply allows for a different approach in the context of 181 to AONB, climate change, greenbelt, all the other national policy objectives. It's not a lack of rational, there's no defendable ring fence around 181, which therefore leads to, in my submission, very substantial concerns for the practical operation of the planning system of the consequentialist argument adopted below and by my learned friends. Every time a pre-commencement condition has to be discharged, even at the reserve matters stage where you've been through here years. I mean, outline permission was granted in 2015. In 2024, and we're being told you have to consider the effect of the whole development for national policy objectives. Well, it goes round in circles for decades. You got my point. My lord, can I then take you to Wright?
Yeah. Is this still on ground two?
Yes, then that's it. I just wanted to show, because Wright is dealt with a bit fleetingly in the skeleton. Having been over it, it occurred to me that it may provide more assistance than I've given you so far.
What tab is that?
It's 24. Excuse me. Start again, if I may, with the. In fact, I'm going to take it to the judgment on the head note. Page 405 of the bundle, 6565 of the law report. This was about a wind turbine. You see in paragraph 1 that the developer interested party had got a planning permission for. One of the factors they put forward at paragraph 2 was a promise that they'd make an annual donation to a community fund of 4% of their turnover from the wind turbine. So a financial benefit which they said had public benefit and therefore was a material consideration. The council took it into account. Mr. Wright, the claimant for judiciary, paragraph 3, said that wasn't a material consideration. It was essentially a bung. That was. Paragraph 4, the issue is whether the promise to provide a community fund donation qualifies as a material consideration. Again, this is in the context of broader consideration, but obviously I'm in a stronger position here because we're in the narrow situation of conditions. There's then, just to give you the tour through the judgment, at the next page, there's various national policies relating to renewable energy cited, the most relevant of which is over the page 14, where there's a quote from DEC, that's what was then the Department for Energy and Climate Change, guidance. DEC guidance referred to 11, but it's quoted at 14. One of the things that's said as a community benefit to be considered community benefit funds. So guidance referencing the kind of thing that was being put forward by the developer, which Mr. Wright said was, despite the policy, was an immaterial consideration. Then 32, paragraph 32, page 412 of the bundle, 6572 of the report. There's reference to a judgment of the House of Lords in a case called Newbury, which was directed at conditions but has been held to apply to material considerations generally, which set out and then it's quoted at D to E, considerations must fairly and reasonably relate to the development permitted. 34,
So just to take that principle, why doesn't that apply here?
because that's talking about section 70, subsection 2, general material considerations, not planning condition material considerations.
But how are they distinguished then? I mean, you're not saying, are you, that you can only have material considerations that fall within the scope of section 70, subsection 2, are you? Well, I mean, material considerations can exist for the purposes of decisions that don't come
Yes.
within that section. So, why? What is the principle that you're?
The principle, it's a public law principle, is obviously in any public law decision there are material considerations. What my Lord Justice Singh was saying, in a planning application context, application planning permission, the answer to where does one find the source of the material considerations, where do we look? It's section 70, subsection 2. Now, obviously then, that on one level doesn't help because it says material considerations, but the case law on what are section 70 material considerations in planning generally, the newbie criteria, are relevant there. In the context of a planning condition, application discharge, again, the question is the same, what are the material considerations? Answer, what the condition says they are. Because otherwise, again, think about it in the general sense, otherwise in the context of discharging a tree condition, you'd have to have regard to considerations that have nothing to do with trees, but maybe materials development.
But Ben, I understand the submission you're making. Well, at the moment, speaking for myself, I'm having difficulty in seeing is how what you've cited in Wright supports that proposition.
Can I just finish the journey through Wright, and then I hope that you will. If you don't, then obviously the case doesn't harm me, doesn't help me, but I will hope that you will in a moment see that. So I'm just really providing context, the passage I do rely upon. So the point is that the criteria, as they're called, at D to E and 34 are applied generally to section 70, subsection 2 material considerations. That's just the context of the passage. Then 37, one application of that principle is that a planning permission can't be bought or sold. The principle is the general, an application, which is, channels a little bit of what my Lord was saying earlier, 37. Then 39, in my submission, is of some importance because a principled approach is important, both the protection of landowners and the public interest. That's said in the context of section 70 material consideration. My submission, ditto planning conditions. So that's why I say if the court's with Mr. Moore's, the court's got to either accept the broader impacts of the consequentialist approach or find a principal basis for ring fencing paragraph 181, which there isn't. Otherwise, the court would not be making a principled approach. Then over the page, 42, the court refers to LSIC as Aberdeen, the same cases, but 42, there is a reiteration of the LSIC principle. Statute cannot be overridden or diluted by general policies laid down by central government, nor by policies adopted by local planning policies. And of course, although the statute doesn't overtly, so all of this is effectively the operation of the statutory scheme of the Town and Country Planning Act, and hence the reference to material considerations there is. Then there's reference to Aberdeen. Now, 43 may be for some assistance to understanding how the court saw LSIC. This is Lord Sales, and if I recall correctly, Lord Sales was LSIC too. That it wasn't simply about tax, because Lord Sales read across LSIC to, albeit there was different financial consideration, again, was application of the general principle about what is and isn't material. And then 45 is the key point. Mr. Martin Kingston, for the developer, said that the planning statute has to be always speaking so far as concerns what counts material consideration, and therefore the concept of a material consideration in the section 70 subsection 2 concept, i.e. what, not in the can or can't, but in the mandatory aspects of viewings, should be updated in line with changing government policy. I do not agree. Say that the meaning of the term changes according to what is said by ministers in policy statements undermine the position that what qualifies as material consideration is a question of law, on which the courts have already provided authoritative rulings.
Sorry, where exactly are
So
you?
45H through to the next page, A to B.
Oh, I thought we were going to 47, but 45, yes.
45, yes, 45. I said 47, I do apologise.
No, no,
45.
I think it's my note, yeah. Yeah, sorry.
So, well, I rely on the whole of 45 for reasons I hope that are clear.
So can I be clear? Is it your submission that paragraph 181 is not a material consideration?
It's not paragraph 181 itself isn't a material, it's does paragraph 181 introduce material? What's the effect of paragraph 181? Does it make material the habitat issues? It's not whether because it is what it is, just as in LSIC, the question wasn't was the development land plan policy material, what was the consequence of the policy? That maybe there's different ways of saying the same thing, in which case the answer is yes. But the way I would urge the court to analyse it is, what is the effect? Bear in mind, of course, paragraph 181 is expressed in that general terms. It doesn't say at discharge and condition stage you should ... It is simply saying habitat sites should have the same level of protection. The question is, does that have the effect of making legally relevant the various matters that were taken into account on terms of phosphate loading from wastewater, etc., which were legally irrelevant under the condition?
So that's what I find a little puzzling about this argument, because I could understand an argument that said, under the statute, it's got to be a material consideration to be considered. Paragraph 181 is not a material consideration. That would be a nice, clean, straightforward argument. But that's not your argument.
No, it's certainly not my primary argument. I mean, it's probably different ways of saying the same thing. But the reason I'm a little hesitant at that is paragraph 181 does have relevance in other contexts because it's expressed in those general ways, which is why I suggest the real question of the court is what's its legal effect in the context of a discharge of conditions.
Just if you've answered this question already, just remind me of what your answer was, and I'm sorry if I haven't gathered it. Can we just focus for a moment on what is a material consideration for the purposes of condition 4?
For the purpose of condition 4, the surface water condition. We'll have to go back to what condition 4
Yeah, I mean,
says.
can you tell us what you would submit were the material considerations, not what were the immaterial considerations?
Yes.
What was actually material? Because condition 4 is probably the one of central focus, isn't it, really?
Yes.
You want to get to the
I'm
condition
just
and then you
trying-
can help
sorry,
us
forgive
with
me, I've
that
got the wrong bundle, I think.
point.
I'll answer that question in two ways.
Yeah.
So first, if we go to condition 4 itself, which is on page 179 and 80. And I don't mean to sort of dodge it, it's what the condition says. So starting at 3 lines down from 180, the drainage strategy shall ensure. The question is, within the constraints set by the already approved site-wide drainage strategy, approved under condition 4, the outline, it requires also consideration of both the outline condition 4 and then the details approved pursuant to it. Within those constraints, and consistently with that, does the drainage strategy ensure that surface water runoff post-development is attenuated on site and discharged at a rate and volume no greater than greenfield runoff rates and volumes? And does the evidence base relating to that have the details listed in the bullets?
And the third bullet point, which you highlighted
Mm.
when you took us through this earlier, includes the phrase without causing ... pollution.
Well, without surface water causing pollution, not without wastewater causing
Oh, I see.
pollution. And the works required off-site, or the potential works, are works to deal with surface water pollution. We know from Natural England guidance that the nutrient neutrality off-site mitigation is to offset wastewater pollution.
Well, are you saying then that that unless one finds the word wastewater somewhere here, wastewater would, put aside all the submissions you've already made, wastewater would of itself be an immaterial consideration?
Yes, because it's dealt with separately. So if I can ask the court to go to the outline permission again and go within that. Sorry, the outline permission is at page 90. Go to 7, condition 7 on page 94. So the outline permission has the parent condition, if you like, of the surface water condition was outline condition 4. And then there's a separate condition dealing with foul water drainage. And you see that there in that scheme. So the structure of the condition of reserve matters together treats foul water separately from surface water in that way.
Right, it may be obvious, but had condition 4 referred explicitly to wastewater, then
That'd be a difficulty.
that would, well, your case would be in terminal difficulty.
I think it probably would, yes. I mean, we would have had to challenge the science. You know, we'd have to say Natural England were wrong, which we never did. Yes, it would. You're right. Yes, it would have been.
So I just want to be, I don't want to be unfair at all. I just want to be absolutely clear. If condition 4 on the reserve matters approval,
Well, subject to the constraints posed by the outline permission, so there'd still be the parent condition point, the fact that this had to be consistent with what had been, but subject to that, if condition 4 had been a wastewater rather than a foul water condition, and if the variables left to it.
rather than surface water, you mean?
Oh, sorry, did I say yes? I got it the wrong way around. Yes, if condition 4 had been a foul water or wastewater condition, and if the variables left by the approved material at the earliest stages included parameters that had a bearing upon the Ramsar, that would be a different case. But that's not what the condition says, and it's not how the case was decided. But I think.
Lord Bernard, can I just look with you, please, at page 94?
Yes.
I think the moment that they were showing us
Yes.
condition 7. And I note the terms of condition 6 do expressly refer to surface water drainage. Is that the point that you're making? That if they had intended to refer to foul water drainage, then they were well capable of doing so. And these, I think, you've described as the parent conditions. So have I got the factual picture correct? That at some point somebody has decided that on your submission, somebody has decided we no longer need to be worried about foul water drainage. So the parent condition number 7 doesn't find its corresponding condition in the reserve matters stage, whereas parent condition number 6 does find it.
And there's a
Is that right?
yes. There would be evidence from the bar, but the reason they are the way one deals with them both in practice is different. So for surface water, if you see, there's the creation of these ponds, the attenuation basins, that you make sure things run off into that. And that inevitably requires a strategy, and then you get more granular as you set out the strategy, and then at reserve matters and detail stage, you show that you deliver the strategy. For foul water, of course, it's basically stuff that comes from the domestic drains into the sewage system, and ultimately that often can be dealt with in one go there's often under the Water Industry Act there are agreements that can be there's a right to connect to the sewer. Then there's often an agreement with the relevant water undertaker, etc. So though they both have the word water in them, the way developments handle the surface water and foul water are usually quite fundamentally different, which is why they tend to be. I can't remember ever having seen a condition that deals with the two in one together in nearly 20 years of practice.
So is it your case that what happened factually in this case was that at some point somebody was concerned about foul water drainage? That's why
Yes.
Condition 7 was attached to the outline planning permission,
Yes.
page 94, and that's a pre-commencement condition.
It is.
Yes. That's absolutely clear. The reason for imposing it is absolutely clear. To ensure that proper provision is made for sewerage of the site, the development does not increase the risk of sewer flooding to downstream property. So have I got the factual picture correct? That at some point somebody must have decided, well, that one can now be ticked off.
Yes, I believe I have to get you the. I have to just double check, but I believe that Condition 7 has been ticked off. In fact, if it hasn't, then when we come to tick it off, we're up against the same issue. But I need to just triple check when it was.
It may be important to know
Yes.
whether Condition 7
Well,
has been discharged.
It was dealt with by the inspector in the DL. If you remember, I took you to how he dealt with Condition 7. That is, should we just have a look? It may be that the answer to that's in there. Yes. 33. The inspector certainly proceeded on the basis that whatever Condition 7 required to be approved had been approved. That's page 79 of the 79 of the core bundle. So whatever the outline permission thought needed to be shown in relation to foul water had been shown, signed off, not judicially reviewed, formal validity, etc.
Yeah, I think you're really emphasising the last sentence of paragraph 35.
Yes. And last sentence 33, yes.
Right.
I don't want to take the court away from the point you feel I've seen my Lord Justice Limbaugh looking at the clock a few times. I'm probably a bit behind.
No, just
hard, just to
only
flag
only
up,
to
but,
see only to see how we were going, but not in any way to evince alarm about.
But just to give you, I'm probably about half an hour behind where I should be. I'm going to try and streamline over lunch what I need to take you through later. But
All right. Well, then we've had to ask.
no,
these
absolutely
questions.
not. No, that's no way complaining at all. I'm happy to deal with whatever questions you have.
All right. Fine.
Let me just then pull all that together. Can I just go, just to finish off, because I think we were midway in right, can I just wrap up right, and then I think I can wrap up round 2. We were at 45, and I just wanted to highlight 2 further paragraphs and the particular formulation that the Lord Sales. So at 48, having at 45 set out the board proposition, which I've referred to, that material considerations under section 70 don't change in line with policy, and I say all the more so in relation to condition material considerations. At 48, he looks at various cases that Mr. Kingston sought to rely upon for the contra proposition. And very last line of 48 on page 4 and 6, no support for the submission that the statutory concept of material consideration varies according to the content of planning policy documents, and ditto the same formulation at the end of 49, statutory concept of material consideration varies according to the content. So in my submission, how does that help? Because we're not in the statutory. Well, again, if that's right in the case to which section 70 applies, surely it must be all the more right in the more narrowly focused situation where section 70 doesn't apply, because we're within the concept of a pre-commencement condition. Otherwise, there would have been a rather perverse situation where the range of material consideration for discharge of condition would be broader than for a planning application. That can't be right. So, my lords, probably, unless you've got any questions, I would be inclined to move on to part 3 of my submissions, which is the habitat regime.
Anything?
Richard? Okay, yes, please do.
Thank you, Michael. What I'll try and get through the legislation before lunch, and I can start making submissions on the legislation, the case law after lunch. I may not
Yeah,
quite.
I mean, you bear in mind that we are, I
Familiar with
hope,
it.
familiar with the legislation.
Yes. And obviously, if I'm going to tell you stuff you already know, please just move me along as you would anyway. Directive first of all. So authorities tab 3.
So we're now into grounds 1 and 3,
We are, yes.
and you're taking them together, effectively.
I do.
Right, so,
And so authorities bundle tab 3 is the Habitats Directive, and the relevant provision is at page 12, Article 6.3, and the project which isn't directly connected with management, etc., but which is likely to have a significant effect, either individually or cumulatively with other plans or project, shall be subject to appropriate assessment of the implications to the site in view of its conservation objectives. And then there is this, that in light of the conclusion of the success of the assessment, the competent national authority shall agree to the plan or project only after having ascertained it won't adversely affect, subject to what's called EROPI, but they're not in play here. Imperative reasons of overriding public interest. So the obligation is that they shall agree to the plan or project only having ascertained no adverse effect on site integrity. The language of the directive, also we'll come to the case law after lunch, language of the directive is silent on whether in the context of a conditional grant of planning permission, the point for assessment is the grant of a permission for the project or also the discharge of conditions attached to that permission. And if so, whether the scope is confined to the scope of the conditions. So there's an outcome required by the directive, but the means of achieving that outcome is not prescribed. That's of some relevance, I say, given the principle of procedural autonomy, which I'll take as read unless someone asks otherwise. And as we'll see, there's no Court of Justice case law specifically on this issue in the context of not RM, but discharge of conditions in the habitats context. There's cases on EIA, as we've seen, there's cases on reserve matters, there's cases on voluntary appropriate assessment. There's not a case in relation to where it's said that it's mandatory to do an appropriate assessment in the habitats, as opposed to EIA context, at the discharge of conditions, as opposed to reserve matters stages. So that's the directive. Oh, and yes, you've got the agree to the plan or project. Just to put some context on the EIA case law, we've put in the new clip at tab 6, the EIA directive. For the reason we put that in largely is for the definition of development consent, which is considered by some of the European case law. And you see that on, actually it's not, I don't think it is paginated, but it's Article 1, 2C in that clip. Development consent means the decision of the competent authority or authorities which enables the developer to proceed with the project.
I'm so sorry, which tab was
That's
that?
tab 6 of the new clip.
Thank you very much.
Tab 6, it's the second page, so literally over the side, on the two sides of printing, Article 1, 2C. The decision of the competent authority or authorities which entitles the developer to proceed with the project. What I draw attention to, we'll see how the case law deals with it. It's not the same wording as agree to the project. Different words. So that's that. Then the regs. I'll start with the version in the authorities bundle. I am going to take you fleetingly to the fuller version where we have to go through those parts. Just for your note, submission of the regs, skeleton paragraphs 21 to 41. Proceed. The regs are at tab 5.
sorry, 21 to 41.
21 to 41.
Yeah.
The regs are at tab 5 of the authorities. I will come back to 9. We'll start with the assessment provisions, which start at page, or the 60 ones, page 32. I will come back to regulation 9. So part 6. And 61 and 62 are very important to my proposition that the respondents' approach and the Cranston approach are contra legem. They give the legislation a meaning that language can't bear. The reason why they're important, 61 makes clear the assessment provisions, which is a term used later on, mean 63 and 64, which correspond to Article 6 in essence. Then at 62, the requirements of the assessment provisions, we don't need to concern ourselves with the review provisions, the assessment provisions. So in other words, the requirements of 63 apply, A, subject to and in accordance with, very important words for this particular case, subject to and in accordance with the provisions of chapters 2 to 7 in relation to the matters specified in those provisions. And I'll come on to what that means in a moment. And then subject to regulation 63(7)(c) in relation to all other, and I emphasise the word other, plans and projects not relating to matters specified in chapters 2 to 9. And what I take from that, and indeed actually what Mr. Sir Ross took from that initially, at paragraph 47 of the judgment, was that when you have a planning project to which chapter 2 relates, as he held this did, and on that point there's no respondent's notice, when you have a planning project to which chapter 2, the requirements of section 63 apply subject to and in accordance with chapter 2. And there is no freestanding application of section 63 outside of that. And that's in my submission, as I'll develop, the only tenable approach that the language of this provision can operate. Paragraph 47 of the judgment, which I won't take you to now, but that's where you find the judge accepting my submission below that this is a planning project to which the chapter is related. This is now the point where I need to take you to the clip. Just to, again, if you like, do your whistle-stop tour of chapters 2 to 7 to see how 62(1)(a) operates. So the clip is behind 5. Just to be clear, this has now been amended post-Real Act, so things are slightly different now, but this was the law as of the time of the decision. And if you go, and it's literally a whistle-stop tour for present purpose, within the clip you see this very small page numbers at the bottom of the page, bottom centre. If you go to page 7, you see chapter 2, planning. I'm literally just going to show you the chapter. So chapter 2, planning, there is then several pages of application of the assessment visions to planning. You then go to page 18, chapter 3, highways and roads. Hope it's now become apparent why I put this clip in. Highways and roads, page 19, chapter 4, electricity projects. You then have a little bit further on, 22, chapter 5, pipelines. Next stop is 25, transport of works. Then next one is 27, environmental controls. So things like environmental permitting, incinerators, and landfill. And then 30, land use plans, chapter 8, page 30. And then lastly, chapter 9, very last page, no, penultimate page, 36. Chapter 9, marine policy statements and marine plans. So, I'll just pause and then going back to section 62.
Regulation 62, yes.
Regulation 62, indeed, sorry, forgive me. Regulation 62, and indeed what follows, is very carefully carefully drafted and carefully prescribed that when something falls within a project falling within one of the headings I've just shown you through, you apply the assessment provisions subject to in accordance with the several tens of pages of law I've shown you. You don't give it freewheeling application separately, subject to in accordance with. And subject to is quite important because it's said below, it said there's nothing prohibiting the appropriate assessment, nothing in the regs that prohibits. Well, subject to, it's not just accordance with, subject to. My submission, it's clear that those words are limiting the application of the assessment provisions to the particular ways outlined in the chapters that follow.
Wouldn't you have to show some specific provision in chapters 2 to 7, which you're relying on?
Can I do that now, my lord? Actually, yes, absolutely. Yes. So can I go to section 70? Sorry, regulation 70, and that's we'll go in the authorities bundle clip. It doesn't really matter, but I've marked up the authorities bundle clip, page 49. So this is in the context of chapter 2. So for a planning project, which this was, it wasn't an other project under section 62(1)b. For planning project, the assessment provisions apply in relation to, and there's a list of the situations in which the assessment provisions apply for a planning project. And they don't include discharge of condition. They're quite a lengthy list. And what I say, the consequence of the judgment below and my learned friend's arguments is to add a new category to that list.
That's a different point, if I may say so. If Regulation 70 does not, said it does not apply to what we're dealing with, then I could see the argument that the phrase subject to means that you can't do something, you can't be required to do something under 62, which you're forbidden from doing under 70. But it doesn't do that. What you're relying on is silence.
I am relying on silence to that sense, but read in context, it's clear, given the careful circumscription that this, the whole regime has, it's clear that this is an exhaustive, it's not a, it's an exhaustive list rather than a clue. So it probably goes to that principle of construction, to how you interpret a list. Because otherwise, what's the point? What's the point of having all of okay, when one looks at it's probably a point that will be easier to consume, if you like, in your own time after, when you go down and actually go through the legislation at leisure rather than at pace. But it's so detailed and prescriptive. What would, if you can simply add anything, why have this? Why not just have regulation 63, which I'll show you in a moment or possibly after lunch? There would be no need for this. And this is intended to be a carefully calibrated transposition of the general duty in the directive. And that's why I'd say that section 70 is, section 71 is a closed list. Can I just take you through some of the details section? So 71 applies to, amongst the things, granting planning permission. And to give you a advance notice, my lord, after lunch I'll show the habitats. The Habitats Regs Regulation 86 says this whole part has to be construed at one with the Town and Country Planning Act. And I'll later show you that the Planning Act, after lunch, describes conditions not as a consent but as regulating a development. So there's a further layer on this. But the assessment provision apply, granting planning permission on an application, and then various other things, as you see, over the page. Again, various other things. If it applied to any sort of consent, so why have this list? Then at 2, this is also of some illustration where the assessment provisions apply. The competent authority, i.e. the decision maker, may, if it considers the adverse effects would be avoided if the permission was granted subject to conditions, impose those conditions. 3, diddly, where the assessment provisions apply, outline permission must not be granted unless the authority is satisfied, whether by reasons of conditions, limitations, otherwise, that no development likely to adversely affect a site could be carried out. So what 70 subsection 2 does in relation to a full grant of permission, and 3 does in relation to outline grant of permission is what Dr. Bose and I describe as front load consideration habitats. You don't park it to, you don't grant the consent unless you're satisfied that you can lock out scope for adverse effects, if necessary, using conditions. So that's what, and I'll come on to why that's, after lunch, why that's consistent with European law. Can I then, there's no hint in Regulation 70 that discharge of those conditions itself engages appropriate assessment. I think there's just time before lunch to take you 63. And the case against me, essentially, 63 has some freestanding effect beyond the prescribed situations. And 63, which is page 34 of the clip. Various observations. One, competent authority qualified to undertake or give any consent, permission, or other authorisation for a plan or project, etc., must make an appropriate assessment. Bearing in mind the terms of section 62(1)(a, the consent, permission, or otherwise authorisation, when you read 63, subject to and in accordance with Regulation 70, the consent, permission, or otherwise authorisation is the list in section 70, subsection 1. That is reading 63, subject to and in accordance with Regulation 70. A potential other way of looking at it, I don't need to make this point, but it may or may not, is this is sort of eustem generis approach. So consent, permission, other authorisation is a planning permission. An environmental permit for an incinerator, which is subject to a different chapter, might be seen as a consent. A Transport of Works Act order under the transport might be seen as another authorisation. They're looking at the primary thing, not the consideration of discharge of conditions.
Could it be said that an authorisation is something without which development cannot proceed?
No. My submission, that's too all-encompassing, because obviously that would include a condition, but conditions aren't. Can I show you why that would be the case? Well, by reference to 63, because if you look at 63(6), 63(6), a conditional consent is still the consent, even under the freewheeling approach to 63. And considering whether a plan or project would adversely affect the integrity of site, the competent authority must have regard to the manner in which it's proposed to be carried out, or to any conditions or restrictions subject to which it proposes that the consent, permission, or otherwise authorisation should be given. So clearly, on any domestic approach to construction legislation, the conditions are something separate to the consent, permission, or other authorisation. There are things attached to it. They're not it. And that's at a piece with my reading of Regulation 70 too.
But in our domestic law, I understand the concept of a consent, and I understand the concept of a permission. But on your submission, can you give me an example of another authorisation?
Another authorisation? Yes, I can, by reference to the chapters. So because bearing in mind section 63 has, for the various projects in the chapters, has to be applied pursuant to those. So let's look at, let's go through chapter 5. You can turn page 22 of the clip, which, if you remember, is behind tab 5 of the material.
Sorry, which page?
22, authorisations under the Pipelines Act, 1962.
So it's a different kind of authorisation.
Yeah. And if you just flick through, there's actually, and this may be rather illuminating, all the various headings. When we look through it, they're either consents, permissions, or authorisations, actually, funnily enough. Because you turn the page back.
Sorry, what's the difference? A permission is a consent, and a consent is an authorisation. They're all synonyms, aren't they?
They are the government, so it depends on the regulatory regime. So they often talk, so in the planning context, we talk about planning permissions. In the environmental permitting regime, which
The effect would be the same if you called it a planning consent or a planning authorisation.
yes.
They're synonyms. Yes, different labels are attached, apparently, in different contexts, but the meaning is the same.
Well, that's sort of my aestum generis point, my lord. So Yes, and then that begs the question of what's meant by that. And I say it's regulation 63(6) is a clear contradiction between the, I don't want to use sort of mixed metaphors, parent document, the governing document, whether it's a consent, permission, authorisation, and conditions which have to be attached to it to rule out at that stage, in the planning context, the grant of permission, they have to be attached to it to rule out. They themselves are not the discharge of them is not the consent. So 63(6) is the generic illustration of what Reg 72 and 3 do in the planning context. They say you have to front load the assessment. You don't give the original go-ahead to the project, which is the grant of planning permission, or the electricity consent, or the environmental permit. You don't give the go-ahead unless you're sure that the conditions lock out any effects. You don't just say, well, we will leave it to the condition. It'll come out in the wash later.
All right, so I understand that submission, but one last question, if I may.
Sure.
I can understand why you say that the imposition of a condition is not either a consent, permission, or authorisation. But why is the release of a condition not a consent, permission, or authorisation?
Because it's not described as that anywhere in the legislation. It's all at a piece. That's why it does take some. If you go through
You need to go ahead.
excuse me.
It's what you need to go ahead.
What you need to go ahead, but which you only get if the governing when this regime is operated lawfully, you only get it if the parent document, the governing document itself, rules out effects. So you don't need to appropriately assess the discharge of the condition because you've already secured a condition which the parameters of which won't involve any adverse effect. That's the parent document that has to do the job on its own. And that's why you don't get into the minutiae of the conditions. And then, if that's right, then the only question becomes about timing for judicial review and formal validity and noble. And do you reopen matters or do you assume that it's all been done correctly? Is that a convenient moment? I don't want to half answer my lord or just answer questions. Is that a convenient moment?
Come back if necessary
Yes.
to that point after the adjournment. 2 o'clock.
Thank you, my lord.
Thank you.
Court rise.
We might review progress at that point. We might review progress.
Yes, thank you.
Thank you.